Okay, so I've just started the recording now. So we'll start with the session. I'm going to hand over to Julie to introduce us and start leading the discussion on disciplinary processes.
Great, thanks, Gareth. So, good morning, everyone. Again, I'm just going to dive straight into the kind of the very foundation of the disciplinary procedures. Obviously, it's failure to follow the correct procedures when dealing with a disciplinary issue can leave you open to problems with morale, not to mention obviously costly claims. So the first thing I want to look at is disciplinary policy and procedures. Why is it important to have written policies and procedures? Documenting the rules in writing means that your employees know what conduct is and isn't acceptable in the workplace. And so obviously that first step hopefully encourages everyone to behave appropriately without the need for a disciplinary. But your disciplinary procedure is the means by which you outline and maintain these expectations, and it lets your employees know what they can expect should they break the rules. So it's important when considering the content of any written disciplinary procedure not to make it too prescriptive. So for instance, whilst it's common to list the types of conduct that will merit disciplinary action in general terms, it should be made clear that any lists that are not exhaustive and for guidance only, and that ensures that your policies are flexible and wide enough really to cover all eventualities. So what can go wrong if we don't follow a fair disciplinary procedure? So if you were to dismiss someone without having good reason for the dismissal, or by not following a fair disciplinary process, then they can bring a claim against you via the employment tribunal. So there's two key issues. There's one that's process driven that could let you down, and there's one that's kind of content driven if you're disciplining someone for something that's manifestly trivial. And that would allow them to potentially bring a claim for unfair dismissal. And such claims can be brought after an employee has 2 years service, subject to some limited exceptions. And compensation is currently capped at a year's salary, which is in itself capped at £93,878, to be very precise. So that's the liability potentially if you get it wrong. And I think Gareth's going to go into the first part of the actual practical manifestation of the investigation.
Thanks, Julie. Absolutely right. So the investigation stages, as we know from handling disciplinary processes, is the starting point of any process, any procedure. Now, often we get asked whether an investigation has to be carried out into any and all disciplinary offences before disciplinary action can be taken. Sometimes from employers that may think that that's going to slow things down. Is it really necessary? Everyone can see what's happened. Can't we just proceed straight to a disciplinary hearing or even issuing a disciplinary sanction? Well, the answer is actually clearly that an investigation should always be carried out before deciding whether to discipline an employee. And that investigation may take lots of different forms, very much depending on the nature of the offence or the alleged offence. So the information that you gather, the witnesses you speak to, documents, the footage, CCTV, things like that, will vary from offence to offence. But absolutely, there should always be an investigation carried out before a decision is taken on disciplining an employee. Now, you should carry that out as soon as reasonably possible in order to help you establish an understanding of what's happened and whether or not what you believe was a potential disciplinary matter in fact does warrant disciplinary action or taking things to a disciplinary hearing stage. So you need to ensure that that's carried out with as far as possible an open mind and without jumping to any conclusions about what the outcome might be. Now, in practice, that might be easier said than done, should I say, in terms of avoiding jumping conclusions, but as far as possible, you should look at that investigation stage as an information gathering stage rather than a conclusion or decision reaching stage. And once you've concluded the investigation, you should determine whether that conduct is serious enough to warrant any form of disciplinary action. And we say this because occasionally there can be times when the investigation reveals that the issue at hand, whilst not necessarily approved of or necessarily the best thing an employee could have done. It may be a far cry from the disciplinary type scenario. So anything that's trivial, clearly trivial, doesn't warrant disciplinary action, can obviously be, but the process can be ended at that investigation stage. And that's indeed one form or one of the aims of a successful investigation, to conclude whether or not there is a case to answer to the next stage. Now, the good thing about investigations is that they can be carried out without giving the employee any warning or allowing them to be accompanied to a formal meeting. Much different at disciplinary stage, which Julie will come on to shortly. But at the investigation stage, things are still relatively informal. There's no need to formally invite employees to an investigation meeting. And in fact, this is often the best moment of getting the most truthful, honest, sort of credible account of events when you're asking individuals in question what's happened, what's their version of events, and you're much more likely to get an accurate reflection. That person hasn't had time to prepare, or possibly you might even say concoct a more sanitized version of the truth. Now, we've actually been involved in many cases ourselves where just by undertaking that investigation, asking people about what's happened, can be enough in some cases to kind of prompt an employee to think, well, here I'm going to be rumbled if they call me out, I'm in trouble. Investigation started, it's best to fall on my sword before it goes any further. And sometimes that's as far as things need to go. But if you're doing that in the right manner, collecting the right information, then you're giving yourself the most solid foundation for moving on to a disciplinary hearing if that's warranted. Now, if you decide at the conclusion of your investigation that there is a disciplinary case to answer, then the next stage clearly is to move towards a formal disciplinary meeting. Now, this is where the process takes a much more formal footing. And Julie will take us through some of the requirements of that. But the overall purpose of that is in order to give the employee an opportunity to formally put forward their version of events in response to the specific allegations you've levelled against them, the specific information that you've gathered, and the evidence that you've gathered in your investigation. They will have every opportunity to challenge that, question it, dispute it, explain it, mitigate it, whatever you want to call it, and they will get that opportunity. So therefore, when you make your decision, you're doing so on an informed and much more legally fair basis. I'm going to pass over to Julie now, and she's going to take us through how we actually conduct that formal disciplinary meeting and give us a few pointers of how.
Thanks, Gary. So I'm sure you're all, or many of you, are seasoned disciplinary experts, but it's quite interesting how often the conducting a disciplinary hearing, it's nerve-wracking for you yourself if you're organising it or potentially chairing it. So I'm literally going to go through some of the basics. So forgive me if you think I'm stating the obvious. So prior to the hearing itself, the employee has to be given written notification of a few obvious things, like the date, the time, the place of the hearing. They have to know when it is, where it is, and sometimes you'll have a bit of debate back and forward if they can't manage. So I think you can, be reasonable. But if an employee is clearly prevaricating and, can never attend, eventually, there comes a point where you just insist and say if they're absent, then it would have to go ahead in their absence. But you have to obviously try and accommodate them as best as you can. Let them know the names and the role of the people attending the hearing. And this is the big part. Let them know the allegations against them. That section of the letter should be as detailed as possible. If there were particular incidents, the date of the incident, who perhaps saw it, what you feel a summary of the incident was. You don't want them to come to that hearing and then say, oh, I didn't know we were here to discuss that, or it happened twice and you want to discuss 3 separate events. So that is crucial, because that can really the fairness of the disciplinary process if you haven't done that. They should also be informed of the right to be accompanied. It's either by a trade union representative or a colleague. Sometimes an employer will allow a friend or a family member to come, especially if the employee is perhaps younger, but you don't have to. And sometimes a family member, may be quite a disruptive influence. So again, it's kind of common sense as to whether you exercise this discretion, but it's certainly not their right. They're not entitled to it. Let them know all the evidence that's gathered, that has been gathered during the investigation. If there's an investigatory report, that should really go in the letter so that they can see what they're dealing with. Things like that. And I've also seen letters that can say this disciplinary hearing is your chance to speak up and to provide your version of events. And so if during the meeting you feel you're not getting the opportunity to do that, you should speak up. That's again something that can protect any accusation thereafter, where the employee will say, they didn't listen to me, or I didn't tell them something, and I didn't know I was supposed to tell them that, or all these excuses that can come out after. So once you've got your letter, it's been sent, the hearing is organised and arranged. The person chairing the meeting should follow again a process. Open the hearing, obviously, introduce all the people, present the employer's case. So you're laying out again in great detail the allegations, what's the employee here to respond to. It's not quite, a court, but it's the similar principles, one side against another, and giving that person the opportunity to put forward their case. And that's when you do listen to the employee's case. And that word there, again, I hope I'm not being patronising, but managers should be trained to listen. Don't interrupt, don't put words in the employee's mouth, even if what you're hearing is quite often you think rubbish, easily undermined, lies. You're listening to, this is their best case, so you're writing it down, and you will then obviously have an opportunity to consider it. Of course, the manager can probe to say, well, you said you were outside smoking, but actually, you sent an email at this same time. Obviously, if there are inaccuracies, you can put that to them. But the manager is not Perry Mason. It's not beyond a reasonable doubt. You've just got to get it down in writing, and as I say, listen to their version of events. And then you can adjourn for consideration of the case or both arguments, and the manager should obviously reach a decision, including being quite sure that they've worked out how to articulate a justification for that decision. So that if it's, again, challenged down the line, you said, well, I decided that because I didn't find the person credible, I didn't believe them. That's perfectly acceptable conclusion to reach. Why didn't you believe them? 4 other people said something different, their stories matched up, things like that. Then you should reconvene the meeting and communicate the decision in person. Not a particularly nice part of the meeting, especially if someone's losing their job or receiving quite a serious sanction, but it is best to communicate it in person and again explain the right of appeal in the meeting, and obviously it will be followed up in writing. There are some other occasions when you may want to adjourn the meeting prior to the stage where you're ready to make a decision. Obviously, if the employee becomes unwell, angry, upset, give everyone some breathing time, and it should be noted in the minutes. So-and-so was crying, we were sympathetic, we adjourned the meeting, they got to go and gather themselves. If the employee presents a grievance during the meeting, again, you might want to adjourn, take advice, regroup, consider the next steps. And Gareth's going to discuss some of those steps later. If they raise some unexpected evidence or information which blindsides you, and you yourself want to regroup and perhaps discuss it with a colleague, that's obviously perfectly acceptable. or if the hearing has digressed, it's gone off at tangents, it's taking a really long time, you might need a break just to refresh, recap and refocus. That's code for a comfort break. Everyone just needs to go to the loo and have a cup of tea, and then you can regroup with fresh minds to allow the hearing to kind of come to its conclusion. As I mentioned, it's important, really important, to ensure a written record of the meeting and that the employee is provided with an opportunity to review and agree the minutes. I've been involved in quite a few tribunals that have lived and died on these minutes, and it's funny things that will really help your case. For instance, as I mentioned, if you have had an adjournment because the employee was upset, make sure that's recorded in the minutes. How long was the adjournment? If the employee is visibly upset, record that. Record any soothing things that are said by the manager. You can record the time. That can also show how long the employee has had to give their side of events. All these things, all these key points. Obviously, if there are certain key aspects that are discussed that are going to feed into your decision, make sure they are in the minutes. And sometimes a disciplinary hearing can grow arms and legs, partially because of the person that has accompanied the employee. And so Gareth is going to touch on that and how to handle that extra person in the room.
Yeah, so we're all probably familiar with the rights that employees have to be accompanied to disciplinary meetings, just as they are for grievance meetings and other formal meetings of that type. The legal entitlement, as we know, is that they can be accompanied by a work colleague or a trade union representative. Now, the individual themselves doesn't have to be a member of the union if they have a representative that's willing to attend with them. They have that right. Seen that challenged in the past. Employers say, well, I didn't know they were even a member of a union. That's not a requirement. They have that absolute right if the union is prepared to attend with them. Now, that is the extent of the legal right. And so therefore, employees are not automatically entitled to anything beyond that right. But what we're finding more often, and I'm sure we've all experienced this, is that employees will ask to be accompanied by a friend or a relative or a spouse. Now, that's possibly even more common where your workforce might be slightly younger in age. You might get people asking for their parents to attend and things like that. Now, previously or in years gone by, very much the norm was to refuse that right and limit it to what they're legally entitled to. What we tend to see more and more these days is that can be challenged on a general fairness principle, whereby if it would be unfair in the circumstances not to extend that right, that can potentially go against the employer in the fairness of their decision. So how I tend to approach these things now is to look at it and say, well, as the employer, it's a meeting that you're in control of, you're running that meeting. If you're well prepared for that meeting, you know how you're dealing with it, you know how you're going to structure that meeting. The attendance of an employee's friend or relative or parent or whatever, in most cases, shouldn't influence you, shouldn't disrupt you, shouldn't distract you from what you're trying to do, provided that they stick within the boundaries of what that companion can do at those meetings, which is to support the employee, remind them of information, ask questions potentially on their behalf, but not to answer questions, and not to be disruptive or inappropriate or offensive or otherwise. So in many cases, it can, as Julie was saying before, it can enhance the fairness of what you're doing. It can show the reasonableness of the process if you can say, well, look, we know that your right is limited to a union rep or a colleague, but in this circumstance, we will grant your request to go wider than that. It can just look very, very, it can enhance, as I say, the fairness of that decision. Now, if that companion then attends and is disruptive or causes a problem, you're then within your rights to end that meeting for those reasons, and be very clear that that's why you're doing it. Again, that will reflect badly on the employee, but well on the employer. Equally, you may be aware that from previous experience, well, this employee's been accompanied before or in the past by their friend or their relative or their spouse, and it was an absolute nightmare. It completely curtailed. It went completely wrong. You'd be justified in that circumstance of saying, well, no, it didn't work in that scenario. We're not going to do that again. But just have an open mind to that is what I would say. It's also worth bearing in mind that it is the employee's right within their legal right, you know, for a colleague or a union rep, or to ask for an extended right. It is the employee's choice who they can be accompanied by, and we do see this happen a lot, whereby family members, maybe even married couples, work together, and they ask to accompany each other in various meetings, and employers might quite understandably think, well, they can't have a relative there, can they? But if that relative is an employee, then that absolute right overrides. Again, with all the caveats I mentioned around disruption and playing the correct part in that meeting, which, as you might expect, is more likely to be a risk if there's that personal element involved. But it's just to mention that just because there is a personal connection as well as a working connection, it's the working connection that will override, and the employee does have that absolute right to be their colleague. Now, I also just wanted to mention, before I move on to the different kind of outcomes of a disciplinary meeting, that, as Julie was mentioning earlier about how we conduct how we conduct a disciplinary process, we have seen a few changes that have occurred over, well, primarily over the COVID pandemic, where a lot of these meetings were taking place remotely. They were taking place over Zoom or Teams, and that was absolutely fine. It was making it practically a little bit more challenging, but it was better than kind of not being able to do anything at all. And so that's still an entirely reasonable approach to take. I mention it now just because, having got used to doing those kind of hearings, the possibility of doing it that way can continue, even though we're not necessarily in that same working environment anymore. And that can be important where you're coming up against employees that are saying that they're unable to attend. You know, I can't come into the office. Either it's still due to fears around the pandemic and COVID, or the shielding or whatever, or whether it's to do just with, you know, we've all seen this, where there's kind of related grievances or related stress arguments. You know, I find this a very difficult process. I can't attend. I'm too anxious. The fact we're so used to dealing with things remotely now means you can offer that as an option to say, well, we want this to go ahead. It's important that it does, but we want you to be able to attend in a way that you're comfortable doing. So we can do that face to face. We can do it on Zoom. We can do it by telephone. Putting out all those options can kind of cut through some of the blockers that employees might throw up. And the fact we've got used to it over the last couple of years means it's no longer anything to fear doing it like that. So I just wanted to mention that, because the norm of doing things has slightly evolved. Now, in terms of the outcome and the action that can be taken following a disciplinary meeting, as Julie's taken us through kind of how we conduct that, and we've reconvened and we're making our decision. There are really two key decisions that we need to make at that point once the disciplinary hearing stage has been completed. And that's firstly whether the available evidence is sufficient to substantiate the allegations. So are we saying that the allegation is upheld in full, partially, or not at all? And if we do uphold the allegation, what level of disciplinary sanction or action would be appropriate in the circumstances? Now, if you do decide to uphold the allegations and you are weighing up the type of action or sanction to issue, you'll be looking at quite a few different things. Now, obviously, you'll be looking at the seriousness of the allegation itself, but in a sense, you would have done that already when you're inviting the employee to the disciplinary hearing. You would have explained the sort of range within which you think that allegation would be treated if upheld, so that the employee is clear of what the possible outcomes might be. So, for example, if there is a risk of dismissal, that's been spelled out, or if there's only a risk of, at maximum, a final written warning, that would have been made clear. But once you've done that, you would be considering where within that range the outcome, sorry, the sanction should fall. You would also be looking at whether there's any prior warnings on the employee's record, because that can, in a sort of what we would call a totting up type procedure, it may be that a higher level of sanction is then more justifiable because they've already got a live disciplinary warning on file, and they've previously been told, you know, if this happens again or something similar happens again within the next 6 months, 12 months, then you'll get a more serious sanction. So you'd be looking at all things like that, and all the time you'd be weighing up the idea of what as lawyers like to call the range of reasonable responses. So that is looking at, there's a range of things you could say, but is it within that reasonable realm of things that you could decide? And we like to talk in those terms because not every employer will necessarily make the same decision when faced with the same evidence, but there's generally a range of what might be acceptable. So, for example, an employee, a couple of employees arguing, swearing, at each other in the workplace. Some employers, may think, well, it's a first offence, we'll give a first written warning for that. Others may say, well, no, we don't take anything like that lightly. We've got zero tolerance for that kind of incident. So therefore, we think that is actually a final written warning. And we can see that there may be a range there. Neither of those is necessarily wrong or right, but there's a range there that we can choose from. But if someone dived in potentially and dismissed that person in that context, that could kind of be taken to be outside of that range of responses, reasonable responses, and therefore running the risk of unfair dismissal claims. So it's just about having a serious think about where you think that allegation has been pitched and what sanction to issue. I'm just going to pass over to Julie now to take us through a couple more factors when we're dealing with this stage of the disciplinary process.
Oh, someone always does it, tries to speak when they're muted. It was me this time. So following on from Gareth's point, obviously there's a time limit. Once you've arrived at your decision, you need to communicate it. So how quickly should you do that? Obviously, you need to consider the decision carefully, following the disciplinary hearing, and inform the employee of the decision in writing. But there's no specific time limit on this, but it's best to do it as soon as possible after the meeting and in accordance with any disciplinary procedures that you may have. If it's a very involved disciplinary hearing, you may not want to go back in person and say to the employee that you've made a decision one way or the other. So it may be that you adjourn for several days, or maybe that you do it on the same day. The more complicated it is, I think, the harder it would be to justify a very short decision time. But whatever your decision, it should be communicated in writing. And as we've mentioned, once you've made the decision, the employee should be informed of their right to appeal. They obviously have the right to appeal against any disciplinary action taken against them, not just dismissal, because an employee may feel that the decision is unfair or it's too severe. They might say, okay, I did do it, but I can't believe you're dismissing me or giving me a final written warning. One thing to bear in mind that employees often don't realise is that when someone does appeal, and if you're looking at the whole thing again in the round, sometimes it is unusual, but sometimes you can actually decide to impose a more harsh penalty after an appeal, especially if new evidence comes out as part of the appeal process. That's obviously very unusual. Normally, if you uphold an appeal, you would be lessening the sanction. And if it's a dismissal, the person is obviously reinstated and they shouldn't lose any pay. So they should be paid throughout as if they had not been dismissed. And then I think Gareth's going to discuss personnel dealing with conducting the disciplinary and the appeal hearing.
Yeah, absolutely. So one of the key aspects of any disciplinary process, whether that's at disciplinary stage, appeal stage, even at the investigation stage, is to make sure that the people dealing with it are impartial, that they're able to make fair decisions within that process. Now, generally, a fair process would involve having different people dealing with each stage of the process. So in a disciplinary matter, you would typically have an investigator, a disciplinary officer, and then an appeal officer. And ideally, each would be more senior than the last person to deal with it, to show that each time it's kind of making its way up the scale, there's someone more senior with more authority that's making the ultimate decisions. Now, in some businesses, that'll be perfectly possible. And even if you can't necessarily find a chain of people where you can get more senior at each stage, you can at least match the level of seniority or show that you've got sufficient impartiality and authority to make those decisions. In some businesses, that may not necessarily always be possible. And the good news is that the employment legislation and the employment tribunals will only really judge an employer based on the resources that's available to it. So what that essentially means is, okay, yeah, if you're a big employer, you've got lots of managers, you've got lots of different teams, then you'll be expected to follow those principles that I mentioned earlier, finding different people to deal with each stage. Where you're in a slightly smaller organization, it may not necessarily be unreasonable or unfair where there's some overlap between some of those individuals. Now, that should really be a last resort, but if it is the only resort, then that's not necessarily going to undermine the fairness of your decision. However, when we look at resources available to the organisation, it won't just be in terms of personnel, it may be in terms of their financial resources. And so some small organisations with enough financial resource may also be expected to consider bringing in independent parties or board members, for example, who don't necessarily work on a day-to-day basis, to come in to handle the different stages of the process. So it's just always worth bearing in mind. What we tend to say too, and we all would have this potentially by default, but if not, it's worth revisiting it, of thinking within your own organisation, how would that process run? Who would typically, and what level, and what individuals would typically investigate? Which people would hold disciplinaries, and who would hear any appeals? Clearly, that can be complicated if there is some involvement in the substance of the issue with the managers involved. So, for example, and we see this more with grievances, but it can come into disciplinaries where the usual person who would handle a particular stage can't, because they've been complained about, or they're involved in some other way, or they might not be seen as impartial enough because perhaps there's been previous run-ins, previous fallings out, that kind of thing. So we're always up against these unpredictable issues, but having that plan of who would deal with different stages will really help you at the start, at the outset of handling the disciplinary process. And then I just wanted, before Julie takes us on to a couple of different case studies, I also just wanted to mention something that happens quite often. I'm sure we've all experienced this, which is when an employee raises a grievance within the disciplinary process. And often it can feel like it's simply a response to that disciplinary. You've brought an action against me, how can I respond? Well, I'll respond by throwing the kitchen sink back at you with all these complaints that I've never made previously, that kind of thing. But the important thing there is to take that process seriously. The employee has the right to raise a grievance, whenever that may be, and then make a decision on how to properly deal with that. Now, the general consensus, or the general norm approach in this kind of scenario, is to postpone or pause the disciplinary process to enable you to deal with the grievance. But that's not always strictly necessary. It really will depend on the nature of the grievance, the issues that have been raised, whether it's linked to the disciplinary, or whether something about it, something about the issues make it clear that that needs to be resolved before we can issue a fair disciplinary outcome. So there's no one size fits all, but I'd be looking to avoid allowing the employee to kind of cynically use the grievance process to stall things and prolong the disciplinary to avoid what may look like the inevitable. But equally, you need to demonstrate that you've handled that grievance fairly. And obviously, our last webinar was on conducting grievance processes. Just a tip on that, I suppose, is that quite often, once you get into the grievance detail, you can often see that much of it is a response to the disciplinary issue. And wherever that's the case, it can often be best to say, well, look, the points you've raised are not done. Whilst it is a grievance and we will respond to it, it doesn't necessarily mean that we need to stop the disciplinary process, because they are linked and they are the same issues and they need to be considered and investigated at the same time. And actually, many of the things are a response to the disciplinary allegations, which will then be taken into account. And that can often kind of put the employee on the back foot, where they think their attempts at stalling things haven't quite worked. So again, as I say, there's not a uniform approach every single time, but thinking of things in those ways can help us to stay on track and handle those disciplinary processes. And then Julie's got some case studies she's going to take us through now. So
thank you. So I have to stress, these are hypothetical case studies, just in brief to get us thinking about some of the points that we've made. So here's the first case study. One of your employees, William Smith, slaps a colleague, Chris Rock, at a work social event taking place outside working hours. And allegedly, this was because Chris had made an offensive joke about William's wife having alopecia. Discuss. How would you all approach this? I think the first question is, do you all think that the employer does have to do anything, because it was obviously something that happened outside of the actual workplace? Would you all probably take action? You can raise hands. Who would take action? Yeah. I think because it's a work-related social event, the employer is obligated to at least begin some sort of investigation and look into it a little bit more deeply. I think if they were friends outside of work and they'd had a Barney in the pub, nothing to do with work, you're probably on safer ground to not really touch it unless it really makes its way into the workplace. So with that in mind, you obviously would start with your investigation. Would you be thinking that they both might be disciplined, or would you be focusing on one or the other? So who would focus on William? Who would focus on both William and Chris? Yep. I think, again, that's the thing. Quite often in fight situations or in a verbal argument, although one person is maybe seen as the aggressor, the other person could have obviously been involved in misconduct that has brought it to that point. And obviously the fact that alopecia has been mentioned, you've got potential discrimination issues, because there's something called associated discrimination. So I'm not sure if alopecia is a disability, but it would be something that should be kind of triggering alarm bells, because William Smith is related to the person with the potential disability, and that would be, discrimination in the workplace that the employer would need to be seen to be taking seriously and considering. And the other point that I would raise is that your policy should be wide enough to cover events that aren't necessarily in the workplace, but that are related to you as a business and you as an employer. And sometimes the allegation is that they brought the employer's business into disrepute. Quite often at a work event, you've obviously given the name of the company, and if people say, oh well, Gareth and Julie were having a brawl at the MLP Christmas party, it doesn't do MLP any favours. I won't ask you to take bets on who would win there, because I'm from Glasgow, obviously, so I've got an advantage. So those are all the issues that I would say would kind of be flaring up. But yeah, you're right. You have to really investigate, and they're both probably on the hook. Although William's probably more likely to have a more severe punishment, because it was physically violent, and probably up to and including potentially dismissal.
Thanks, Julie. Just on that, I think that is a really interesting one, because we do see that, and it's a bit of a cliche, but you do see that around sort of Christmas party time, or social event, things that take place, and often an employee's response will be, it's nothing to do with you, it's outside of work. And where that genuinely is the case, then that might be true, because it's not necessarily your business to get involved in someone's conduct that doesn't impact on you at all. But as Julie's saying, if that is sufficiently connected to the workplace, your name, your work event, and an interaction between colleagues such as that, it can justify you getting involved. I just want to mention as well the thing about bringing a company into disrepute, because it is a relatively, I suppose, vague offence or vague issue, and it can apply in many scenarios such as this one. I have seen quite a few employers get tripped up relying on that, where there have been cases along these lines as well, where employees jump to this issue. We've all seen it with PR gaffes that companies make, where they say, well, we're dealing with it this way because it's brought us into disrepute, and the only way it came into disrepute was because they dealt with it in the first place and brought publicity behind it. So sometimes that can be over exaggerated. There's been a few cases where there's one with a supermarket where some employees were play fighting in the warehouse. You couldn't tell where they were, you couldn't tell where it was. It was on YouTube. I think about 6 people had watched it, and then the supermarket chain was Asda, went public with, we've dealt with this, we've dismissed these employees to bring us into disrepute, and nobody would have seen it if it hadn't been for their thing. And the tribunal are very much like, did that really bring you into disrepute? Did anyone really care about these 2 people hitting themselves with plastic bags in the warehouse? I don't think they did. But if you're a famous employer and your staff are fighting at a massive public event, then perhaps it's a bit different. So it's just about genuinely challenging yourself when that comes up to whether that is the relevant issue.
Thanks. And just before we move away from this one, the last question I was going to ask is, would you respond differently if it happened in the workplace? And I think, given what we've said, the answer is probably not, because you've already done everything really that you would normally do in any disciplinary situation. So you would approach it in a similar manner. So the next situation is Donnie Trump, a line manager, informs you that a member of his team, Joe, has a poor attitude, is damaging morale in the team, and he's not treating customers appropriately. So after the initial investigation and prior to the disciplinary, Joe raises a grievance complaining that Donnie is a bully and that the poor working relationship between them is affecting his performance and demeanour at work. So what are your next steps? Obviously, you're obliged to continue with the disciplinary and hear the grievance. So who would postpone the disciplinary and deal with the grievance in isolation? Everyone's been paying attention today. Who would suggest that the grievance / disciplinary hearing is held to address both issues effectively, because they obviously are intrinsically linked? Is that what everyone would do? They'd kind of, they'd run either side by side, or I think you could probably even have one big meeting. I think the key here is absolutely being clear in any invitation letter what the purpose of the meeting is. So we are holding a disciplinary about these allegations. You have raised a grievance alleging about bullying, and we're going to address all of those points in this meeting. An employer could have mini grievance and then immediately a disciplinary. I've seen employers do that where they have on the same day a grievance in the morning and the disciplinary in the afternoon. But I think if as I say, you craft the invitation letter well, because the issues are clearly intertwined, you can move forward more quickly, effectively, by dealing with it all at once, as long as the employee's on board. If the employee pushes back, then you probably would have to look at the grievance first. So, yep, full marks. And the last one is just a small point, but it's something that happens quite a lot. So during our disciplinary hearing, Julie requests to record the meeting on her phone.
That actually happened as well, didn't it?
Yeah, so I know the answer to this, best practice. So what's everyone's response? Who says absolutely not? Okay, who says no problem? Who says okay, but with a few caveats? Is that what everyone's thinking? Yeah. I think employers, in my experience, can get very wound up about this idea of being recorded during a meeting, understandably, because it puts quite a lot of pressure on the manager. But I think if they ask in advance and there's no particular reason to refuse it, but what I would always do is say that you want a copy sent to you, the copy that they're holding immediately after. And what I would also do is I would also still summarize in writing the meeting. So I would still also have your own separate meeting notes. And again, the key there is sending them to the employee after. And if they don't dispute the content of your meeting notes, and they're clearly not in contravention with what has been discussed, then it means you've got a kind of solid record of the salient points, and they've got this recording. What we also have seen is that some people, I would imagine this to be quite difficult, but some people surreptitiously record a meeting. It's obviously more easy if it is being held remotely. And again, employers can say, well, how can that be fair? And surely that can't be used. And generally, although it's frowned upon, not encouraged, an employment tribunal would almost never say that a recording of a meeting which has not been agreed between the parties cannot be used. So they would let it in, even if it has been done kind of sneakily. So I suppose it's a bit like the advice you give to people when they're emailing: don't say or do anything in the meeting that you wouldn't want produced at a later stage, either as a recording or even as a video. Just conduct yourself professionally. Yeah.
The reality of recorded meetings is that they're actually nowhere near as useful as people think they might be. It does become a bit of an obsession in some cases of, I want to record this because I want it to be 100% accurate. But actually, it can be really difficult to listen back to, with all of the kind of verbal tics and ums and ahs and things like that, which are fine in a conversation, but don't, when you're actually in it, but don't actually read that well when you're listening to it. And even worse, when you're actually reading a transcript that's been produced, because quite often a tribunal might say, well, it'd be easy to have a transcript of it, even though you've recorded it. So you end up back to that position anyway, because it's easy to refer to. So I often look at that and think, well, why does that person actually want it to be recorded? Because the meeting notes will cover the gist of what's being talked about, even if it's not every single word. And the notes should and can be agreed and amended and adapted if parties think anything's been missed. Sometimes there can be really legitimate reasons why people may struggle to read meeting notes for all sorts of different reasons. And so that might be the only option, but actually they're just not that helpful very often. The meeting notes are much better. There have been cases where, as Julie was saying, meetings have been recorded and they've been allowed, but actually, even then, the tribunal has said that they won't listen to certain aspects of the recording. I think there was a case, I can't remember all the precise details, but someone had covertly recorded something by putting a phone in their pocket. And then when the meeting ended and the managers were in the room discussing the decision, well, should we make this decision? Should we make that? What about this? What about that? That had all been recorded as well. And that was, the tribunal were very clear that they were not prepared to consider that, because that was a time when the managers had every right to expect that they were in private, weighing up the decision, thrashing out different options and possibilities. And it would be completely unfair to then throw that back at them, just because someone had sneakily recorded it. So yeah, as Julie said, if you go down that route, it's about being very clear what the rules are. Yes, we're agreeing, but only these parts, or only if we all get a copy and things like that.
Yeah. Good. Well, that's the case studies, and I think that brings us neatly to the end. I don't know if anyone's got any questions or any other points that they wanted to fire in our direction. Oh, been stunned into silence. No problem.
Ahead of the 1st of April, when COVID no longer exists and everything's out the window, that general update that we have, which we hate to have, but we keep having to stick on the end of our lovely seminars. What's your Gareth's advice, guidance ahead of Monday when, well, it's Friday really, isn't it? But I think most companies are changing the rules on Monday when COVID no longer exists in the workplace, and government guidance is that we just crack on with life as normal.
I think very much our advice is that it should be treated as an illness, especially because, if someone is feeling ill, it may be that they don't get tested now. They might have a runny nose or something. They don't know now if it's COVID or general cold or the flu. And so again, your sickness absence procedures, I would imagine, will be robust enough to say, if you are not well, we don't expect you to be coming into the workplace. It gets obviously more tricky in relation to asymptomatic testing, especially if an ill person can't work from home. If they're a bit ill, but they could still probably do some work. It may be that you want to continue to fund testing for employees, or you may be expecting them to still source that for themselves. But I think you get into slightly trickier territory with asymptomatic testing. But if someone is ill, then you should continue to require them not to come to work.
I think that the trickiness will come in, won't it, where whose judgment of how ill somebody is. And if we end up back in the environment that we were in pre-pandemic, when there was a bit of a culture of, oh, I'm all right, I'm fine, and people would come in the middle of winter full of cold and spread it around everybody in the workplace, but they've thought it was a badge of honour to come into work, and they were absolutely fine, in their opinion. Clearly, there'll be a line at some point where you can say, well, you're absolutely kidding yourself if you think you're well enough for work. You need to be at home in your sick bed. But you're going to get those people potentially with a bit of a sniffle, a bit of a cough, that say they feel fine, they can't work from home, and they present themselves at work. And the trickiness is that ultimately it's for the employee to an extent to declare themselves well enough for work, in a sense. So therefore, if they do, you have every right as the employee, as the employer, to say, look, we need you to stay away. But the question will be about what they actually have to be paid in that circumstance. Strictly speaking, if you send someone who's presented themselves for work, you send them away, you've got to pay them. That's the old position, that is how it is. In practice, as Julie was saying, you may take the view that we're treating you as sick. You've presented, you've declared yourself well, but you're not actually well. So we're treating you as sick, and see how that's accepted by the employee. And in many cases, that's probably going to be all right. But and you deal with the kind of rogue cases where people say, well, I've been on Google and you can't do that. But take that by, case by case. Ultimately as well, I think you're going to get commercial and practical decisions to make. You're going to have to think, well, okay, if I send this employee home, even if I pay them, it's a bit of a pain. Don't feel like I should have to do that. But is that better than them coming in and then in a week's time, half my workforce is in the same boat, and then a week later, the other half, and I've just got disruption for a whole month. So you're kind of looking at the bigger picture.
The problem being, of course, now, Gareth, is unless you're going to start paying for testing,
Yeah.
and even if you can get a test, I mean, I don't know if anybody else has tried to get a lateral floor test. If anybody else has tried to get a lateral floor test in the last week, 2 weeks, either from a chemist or being delivered, they just simply aren't around at the moment.
Yeah.
I don't know if it's a deliberate move, so there's somebody restart from Monday onwards when you've got to pay for them, but you simply can't even get hold of a test at the moment. So it's going to be difficult, to even get someone to do a test to even know they're positive or not.
Yeah.
I know my wife and my sister both had COVID last week, and they didn't have a single symptom between them. Now we found out is because my daughter's school had a bit of a spike, and they asked all children to test before they came back into school last Monday. So that's the only reason we found out. So we wouldn't have tested under normal circumstances. And that would have been my wife and my daughter both carrying on with life like normal last week, positive, but not knowing they were positive.
Yeah.
I think as well it relates to risk assessing your own workplace. Maybe you have vulnerable employees that are at high risk, and then you obviously need to put in certain measures to protect them, to maybe asking the individuals in their team to test. But I think we're going to see a general move towards employers treating it the same as they would treat an employee with a cold or with flu, and relying on the kind of national vaccination programme, and not differentiating between an employee with the sniffles or and that will obviously also catch the individuals who are asymptomatic, because some employers will just say, well, we don't really have a COVID strategy anymore, other than maybe ring fencing and certain high risk employees. And that, I think there would be a certain defence there if that was challenged, because you're in line with government guidelines, which is back to business as normal. So I don't think you would be doing anything wrong if your approach as an employer, taking into account any high risk individuals, was simply to not even reference COVID any more specifically than you would reference a cold.
And it's what's going to be so challenging about it, not to just pile on the challenges without having all the solutions, but you could go from one conversation with one employee who turns up full of a really bad illness, whatever that is, because they can now, and you'll jump straight to another conversation with an employee who, for whatever reason, legitimate or not, is not prepared to leave the house, not prepared to come into work, still completely frightened of, and that's not to undermine it, but frightened of catching COVID and all of that. So you've got the ends of the spectrum, and they've not gone away. I can see people, I can look at one side of my car on the way into work, and there's people walking down the street with masks on, outside down the street, and you look on the other way and there's an office full of people, cheek by jowl, without masks on, and you're thinking there's such a spectrum of opinion out there. You're going to see it amongst your employees as well. And that's not to say who's right or who's wrong, it's just you've got to manage those two extremes. And the reality is, by changing it, okay, it can be celebrated. The government can say, this is what we've done, we've progressed to this point where we can do this. But they have just passed the decisions on to employers when it comes to these scenarios we're talking about. They've passed it back to us to make those decisions with our workforce and deal with it, and then face the consequences if we try our best but make a mistake. So I think it will probably most likely balance itself out, but if you do get those tricky scenarios, you're just going to have to treat them on a case by case, and obviously get in touch, and we'll support and discuss through in any way we can.
Yep.
Any more questions? No.
Great. It was nice seeing you all this morning. You can go and build a snowman.
Thanks everybody. Thanks for joining.
Cheers.
Thank
Bye-bye.
you.
Thank
All
you.
right. Thanks a lot.
Bye.
Cheers.